A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. This is the Second Amendment, and this is the Gun Guy.
Boom, 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 boom. Bang, 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 bang. Boom, 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 boom. Bang, bang, bang.
With Guy Relford on 93 WIBC.
And good afternoon. I'm Guy Relford, and this is the Gun Guy Show on 93 WIBC. And hope you're enjoying this Saturday afternoon. We've got a lot to talk about, starting with a new statute about to be signed into law in Connecticut that I frankly didn't believe was being accurately reported when I first heard about it, because it is a new law that appears to me to be utterly devoid of any form of due process. And it's going to strip the Second Amendment rights of Connecticut citizens who haven't had the availability of any form of due process in terms of access to a court, in terms of the ability to be represented, in terms of the ability to confront the witnesses against them, and any number of the other protections we get and what we collectively call due process in this country. And specifically what's going on, and a lot of people when they look at this understand the motives, me included. But what this new law is going to say, because it's been passed by both the House and the Senate in Connecticut, and the governor out there, Dan Malloy, has said he's going to sign it. And what this new statute says, and the effect it'll have as soon as it's signed into law, is that anyone who's been accused of domestic violence, such that a temporary restraining order, or what we call in Indiana an order of protection, has been issued against them, immediately loses their Second Amendment rights and immediately has to either sell any firearms that they own or possess to a licensed dealer or turn those guns over to police. Now, no one should question the motivations of wanting to cut down on domestic violence in this country, and me last of all. And I absolutely support and defend the need to protect people against domestic violence. But there are an awful lot of laws and statutes in this country right now, including at the federal level, that are designed to do that. Now, I don't say laws are enough. I teach classes every month. I teach a ladies only class, and I've had hundreds, if not thousands, of women over the last 20 years who have come through my classes who feel the need to defend themselves because they've been in an abusive relationship. And I absolutely applaud them for taking their safety into their own hands, taking responsibility. And I get it. I absolutely get it, and I support it, and I defend it. And I love the motivation behind any form of legislation that seeks to reduce domestic violence. However, as we seek to reduce domestic violence, what do we also have to have? Due process. Because here's how this process works. If I wanted to go down to the clerk's office and fill out a form at the courthouse that said that I was being the victim of domestic abuse, and you specify what form that has taken, and I can turn that in without a hearing and without even any notification to the individual I'm seeking to be protected from, that order of protection, as we call it in Indiana, or temporary restraining order, as they're talking about in Connecticut, that would issue. Thereafter, and by the way, the reason for that is what? The need to immediately give some legal protections to that person who says that they're the victim of domestic abuse. Okay. And what that does is it orders the person that they say is abusing them to leave them alone. They can say they can't come within so many feet. They can't call them anymore. They can't email them or text them. They have to stop the contact with that person who alleges they've been abused. Well, telling someone to stop abusing someone doesn't strip that person of their constitutional rights. And that's why we're comfortable as a judicial system in having those issued without any hearing, without any evidence, just based on an accusation. And I get it, and I support that. That needs to happen. I also like the fact that a lot of women anymore, and domestic abuse is not a one-way street, we know, but we also know an incredibly high percentage of victims of domestic abuse obviously are women. Well, in conjunction with that legal process, a lot of women are making the decision to also arm themselves so they can defend themselves. And in Indiana, unlike an awful lot of other places that are so restrictive in terms of the ability to get a license to carry handgun and defend oneself, in Indiana, you can buy a gun right away. And you can have a gun in your home to defend yourself against that abusive spouse or ex-spouse, boyfriend, ex-boyfriend, whoever it might be. But ultimately, where the real legal implications kick in, including the disability of possessing a firearm, every place but Connecticut, under their new system they're about to implement, there has to be some due process, including a hearing and the right to confront witnesses, and the right to be represented by counsel, and the right to bring your own evidence to establish that the accusations against you are not true, if they are not true. To comply with the constitutional requirements of due process, the real implications of an order of protection, including your loss of the right to possess a firearm, that doesn't happen without due process everywhere but Connecticut. And under this new statute, as soon as that temporary restraining order, before a hearing has ever been held, as soon as that temporary restraining order gets issued, that person loses their Second Amendment rights. And you know what? A lot of times when we have good motives, proper motives in this country, but we ignore the constitutional protections that our citizens are afforded, then that's a recipe for disaster. That is a system ripe for abuse. It's ripe for abuse by other citizens. It's ripe for abuse by local governments. Why? Because the protections of due process are in place to protect us against exactly this kind of thing. That mere allegations shouldn't strip someone of their constitutional rights. And it doesn't mean they aren't serious allegations. It doesn't mean the allegations aren't true. It doesn't mean that person doesn't need protection. It doesn't mean that we as a society shouldn't do everything we can to protect them within the bounds of constitutional protections. And when you start throwing the Constitution aside in the name of some alleged higher moral principle, that's a recipe for disaster. That's exactly what our founders were trying to prevent. Doesn't mean the motivations are bad. It means your methodology is flawed. Because if you ignore the constitutional protections of due process, Connecticut legislature, you've turned into the criminal. You've turned into the person who ought to be examined for misconduct, who ought to be examined for violation of constitutional principles, because you've ignored them. It doesn't mean your motivations are in the wrong place. It means you went about it the wrong way. You can't throw the Constitution in the trash every time you claim the moral high ground. That's not the way our system of government works. And we love your input. We've got a lot more to say about this. We've got a lot more to say about how our system in Indiana works, including what's the federal law on this issue, because there is already a federal law on this issue in terms of providing protection for victims of domestic abuse and limiting the constitutional rights of those who are domestic abusers. And that's a good system that we have on those issues now, in my view. We'll talk more about that. We also want to hear your view. What are your thoughts on these issues? Give us a call, 239-9393, right here to the studio. You can also call from a cell phone, just pound 9393. Contact me on Twitter at Guy Relford, or on the new Gun Guy Facebook page, which is just Gun Guy WIBC. So join the discussion. We want to hear your thoughts on these issues. We'll be right back. This is Guy Relford on the Gun Guy Show on 93 WIBC.
the show about gun rights, gun safety, and responsible gun ownership. This is The Gun Guy with Guy Relford on 93 WIBC.
And welcome back. I'm Guy Relford. This is The Gun Guy Show on 93 WIBC. And tonight we're talking about a new statute, state statute, that's about to go into effect in Connecticut that will immediately strip the rights, the constitutional rights, the Second Amendment rights, of anyone who is accused of domestic violence such that someone has obtained a temporary restraining order against them, no hearing, no evidence, no representation, no due process. And there's no question about that, by the way. There's not an argument on this. If one party to a dispute goes down, fills out an application, and on that basis, the other party loses their constitutional rights, there is no due process. Period. End of story. So that's not even subject to discussion. And the motivation behind this, we understand. Domestic abusers should lose their constitutional rights. I don't have a problem with that. Domestic abusers should go to jail and lose their constitutional rights. The problem is, who's a domestic abuser? And by what process do you label them that domestic abuser? And should someone who's only been accused of anything, I mean, what's a general proposition? Criminals should go to jail. Yes, absolutely, no question. Does that mean anyone accused of a crime is sent straight to jail? Of course not. Why? Constitutional requirement of due process. The federal government has to give us due process under the Fifth Amendment. The states have to give us due process under the 14th Amendment. That's how it works. Having a person who accuses you of any act, including domestic violence, simply fill out an application that makes an allegation, and that causes you to immediately lose your constitutional rights. How is that constitutionally defensible? Well, that's the question. And I'll tell you what, let's go to the phone lines. And we've got Jim. Jim, welcome to the Gun Guy Show. Buddy, what do you got for us?
Hello, Guy. This is a terrifying law that they're doing. There's 2 points I'd like to make. One, of course, in Indiana, a lot of things count as domestic violence. They're not on the forms that you fill out when you go to get a restraining order, but they're on the statute. Things like writing bad checks on the other partner's account, or arson, or things like that. Those are not on the form because the form is designed to protect women from their husbands, but they are in the statute, and you can get a TRO on that. But the bigger point for Connecticut is that by writing this law, they are admitting what everybody knows, that a TRO does not protect you. That's the real part. And they're missing that altogether.
Yeah, and Jim, thanks for your call. Now, you mentioned a statute that includes like writing bad checks and whatnot. We have a number of things in Indiana that go into the equation in terms of crimes of domestic violence, and that can be very broadly defined. But domestic violence, the specific crime of domestic battery, is actually a harmful or offensive touching of a domestic partner, and that's fairly broadly defined, that involves the use of force or the threat of force. And that's a fairly limited definition. And then we have a broader definition called crimes of domestic violence, which are a broad category of crimes, including just normal battery. It could be criminal confinement. It could be any number of other things, but that are committed against a spouse, former spouse, someone you lived with previously or currently live with, someone you shared a child with. And if a crime involves violence and the victim of the crime falls within those definitions, then that's within a broad category of crimes of domestic violence. So if you go write a bad check on your ex-wife's account, that's fraud, or it's forgery, or it's any number of other things. But when we start talking specifically about crimes of domestic violence, that's got a more specific definition to it. But I don't want to quibble with Jim's more important point, which I agree with, which is, how much good do orders of protection really do, or temporary restraining orders, as they call them, or permanent restraining orders in Connecticut? Well, clearly a lot of abusive spouses or abusive partners, domestic partners, ignore restraining orders, or orders of protection, as we call them in Indiana, and continued to stalk and ultimately hurt or kill their former spouse or former domestic partner. It happens all too often. I mean, hell, there are country songs about, walking right through that restraining order and put her in intensive care, a Dixie Chick song. It's almost part of the culture, and it's a horrific part of our culture that abusive spouses, abusive domestic partners ignore restraining orders. And that's why I've had dozens and dozens of these conversations with students who come to take my firearms courses and said, look, I don't really like guns. I never thought I'd own a gun. But I have someone out there who I'm truly afraid is going to kill me someday, or try to kill me someday, or try to kill me and my kids or my child. And I feel the need to protect myself and protect my family. And that's the only reason I've made the decision to buy this gun. And what I at least like about that is those are of people that have clearly thought about it, and they've also made the decision not only just go buy a gun, but to come take a class and make sure that they're proficient with that gun. They can handle that gun safely. They learn about storing that gun securely, so it's not going to become more a threat to them or their families, and specifically their children there in the home, than the abusive domestic partner is. Because they understand the need, the absolute requirement, prerequisite of learning how to handle a gun safely. But the bottom line is that an order of protection, restraining order, whatever it's called in a particular state, they do some good. And the good that they do is that they are a mechanism for law enforcement to come haul somebody off if they violate it. Now, cops can't be everywhere. The reason a lot of us carry guns and own guns is because cops can't be everywhere. It's kind of a standard response. Why do you carry a gun? Because the cop's too heavy. Well, cops, and they're the first ones. I know a lot of police officers. I interact regularly with an awful lot of members of law enforcement, and they are the first ones to tell you, we can't be everywhere. Sometimes you have to defend yourself. But in that situation where the person subject to an order of protection shows up, they're at the house, they're on the porch, they're sitting in their car out front, then an order of protection is a legal mechanism that allows the police officers to come haul their ass away, put them in jail if they're violating that order of protection, because it's a specific criminal act to violate the terms of an order of protection. And without that, let's say someone used to live there, they still have a key. And without that order of protection, what are the cops going to do if the person complaining, if there's been no criminal act, they're just sitting in their car out on the curb? If there's no order of protection, then what's the legal mechanism by which the police officer hauls his butt off? Well, the order of protection at least gives us that mechanism. It gives law enforcement that tool. Is that always effective? Absolutely not. And I think that was Jim's point. But it can be. It can help. And there are people sitting in jail right now for violating the terms of an order of protection. So not only were they ordered by a court to leave someone alone because they were abusive, and after due process and a hearing and representation and evidence and all the requirements of procedural due process that we have in this country, they were found to have committed a crime by violating a restraining order, so let's park their butts in jail. I got no problem with that. So they do serve some good. I would never call orders of protection utterly useless, but the problem is that they need to be enforced, and you got to have law enforcement present to enforce that protective order, or have the means, the capacity, and the will to defend yourself and your family. And that's what we spend an awful lot of time teaching about at Tactical Firearms Training and at Indy Arms Company. You heard me mention it last week during the show. Taught a course called The Fundamentals of Armed Self-Defense, and we talk about a lot of those kinds of issues right there in that class. But let's go back to the phone lines, and we've got Kevin. Kevin, welcome to the Gun Guy Show, buddy. What you got?
Yeah, hi. I just had to smile. About 10 years ago, I had a guy that worked with me that was arrested 3 times, taken to jail for spousal abuse.
Uh-huh.
And he came in, I don't know, after X number of time and said, hey, I just got my new carry permit.
Oh.
The police don't check this stuff.
Well,
they don't check that. This guy had been arrested 3 times for spousal abuse, and he's still got a carry permit.
Yeah, Kevin, let me tell you exactly how that works, though, buddy. And it's not that the state police don't check it, but it can be a flawed system, and I'll tell you exactly how it can be flawed. The courts, and this is exactly how it works in Indiana and virtually every other jurisdiction, the courts are required to enter into NCIC, which is a national database, and there are several other databases. And Kevin, turn your radio down. That would help too, buddy. Okay. But once someone has an order of protection entered against them, then the court's supposed to send that information into the national databases. And NICS, the National Instant Criminal Background Check System, operated by the FBI out of West Virginia, they check 4 different databases. And at least 2 of those should have orders of protection or restraining orders, whatever you want to call them, in them. And those are checked as part of gun purchases. And the Indiana State Police check those same databases, or at least NCIC and some of the other specific databases that should have orders of protection in them. And then they always check those. I mean, I know the folks down there who do this. I know that because I have hearings down at state police regularly involving people that have been denied licenses to carry handguns. The problem is it can be a garbage in, garbage out process. In other words, if the court that issues the order of protection doesn't send that information into the national databases, then the state police can be extremely diligent in checking those databases, but they don't find it because it hasn't been reported. And that's true of criminal convictions. It's true of orders of protection. It's true of people being found to be mentally incompetent or involuntarily committed. There's a process by which those judicial proceedings or the results of those judicial proceedings get reported into the national databases that do get checked as part of either gun purchases or applications for licenses to carry handgun, for example. But if it doesn't get reported, it doesn't go in the database and doesn't do anybody any good. So it's a fair point, Kevin, that it's a flawed system, but I would take issue that it's flawed because the state police don't check those databases. I know for a fact they do, and I actually have a lot of respect for the process they go through. They can get flawed data, and we have appeals all the time where the databases show that, for instance, somebody has a felony conviction, when in fact that felony has been reduced to a misdemeanor under something we call alternative misdemeanor sentencing. And that the second part of that process, the fact that the felony's been reduced to a misdemeanor, never got entered into the database. So when they check the database, shows a felony conviction. Well, you can't get a license to carry a handgun with a felony conviction, so people get denied. And so we have to go through the process of bringing in the paperwork and demonstrate with certified copies of court records that in fact it was reduced to a misdemeanor. Doesn't mean the state police made a mistake. It means that the record, the database that they were checking was flawed. So, all right, we're at the bottom of the hour, a little past, so it's time to take a break. So, hey, join the discussion. We've had great calls already. We want to hear your thoughts as well. Give us a call here in the studio at 239-9393 or just pound 9393 from your cell phone. Contact me on Twitter at Guy Relford or on Facebook at Gun Guy WIBC. So join the discussion. We'll be right back. This is Guy Relford on the Gun Guy Show on 93 WIBC.
Now you've got a gun guy. Guy Relford on 93 WIBC.
And welcome back. I'm Guy Relford. This is the Gun Guy Show on 93 WIBC. Tonight we're talking about a new Connecticut law about to go into effect. The governor's already said he's going to sign it. It's passed both houses in the Connecticut legislature. And it says that as soon as a temporary restraining order with no due process, no hearing, no representation, no evidence, as soon as that temporary restraining order gets issued, then the person who's subject to that temporary restraining order loses their Second Amendment rights. And, you know, we've talked quite a bit about how this legislation clearly has as its motivation the general concept that the end justifies the means. That, one, we need to protect victims or potential victims of domestic violence. Yes, that's right. That's absolutely right. I agree with that 100%. That domestic abusers shouldn't have guns. I'm absolutely okay with that too. That people who may harm their former domestic partners or current domestic partners need to be prevented from doing so. Agree with that too. Completely on board. So where do we separate? Well, what the sign says outside my office in downtown Carmel says, law offices of Guy A. Relford defending the American Constitution. And I'd be a hypocrite if I had that on the sign outside my office and didn't at the same time want to throw up when I see what the Connecticut legislature did in passing this statute, because there's absolutely no recognition, much less compliance with constitutional restrictions, most specifically the constitutional guarantee of due process. 14th Amendment says the states cannot deprive the citizens of the United States of their fundamental right to due process, what we call procedural due process. The ability to defend yourself. So as I mentioned before, the concept, should domestic abusers have guns? No. But by what process do we label someone a domestic abuser? That's the point. And my prediction is that this law is going to be challenged. And we know what the Connecticut courts will do with it. We've seen too many examples of what Connecticut courts are doing. The Connecticut courts seem to have flushed the Constitution down the toilet several years ago. But eventually this is going to make its way into federal court. And we're going to have a disposition of the issue of, can you deprive someone of property, meaning here their firearms? Can you seize property from someone? And can you deprive someone of a constitutionally protected right, the right to keep and bear arms under the Second Amendment, with absolutely no even head nod toward procedural due process, much less compliance, no hearing, no evidence, no representation, no ability to confront the witnesses against you. Procedural due process. And just to compare and contrast, we have a federal law already. And it's among a lot of gun regulations that you can find in the Gun Control Act of 1968 as it's been amended over the years. And we had an amendment. A lot of people call this the Lautenberg Amendment after the legislator who introduced it. But it's been signed into law as an amendment to the Gun Control Act. And this is a federal law. And many state laws also have this, as Indiana does in a slightly different version, that says two things. If you're convicted of a crime of domestic violence, you can't own a gun. You can't possess a gun. And by the way, under the federal statute, that includes a misdemeanor crime of domestic violence. Same thing in Indiana. And how's that work? Well, we have to comply with both. So here they're under two separate legal principles and different statutory schemes, one federal, one state. You can't possess a gun if you've been convicted of a crime of domestic violence. But the federal statute and state statute both limit that part, that issue, to having been convicted. Well, how do you get convicted? You go to trial, or you plead guilty and waive your right to trial. And the Fourth Amendment is observed. Procedural due process is applied. You don't get convicted without due process. And it says that very specifically in both state and federal statute. Now, in addition, the federal statute, again, what we call the Lautenberg Amendment, is just an amendment, an addition essentially to the Gun Control Act of 1968. If you ever want to look this up, there are a whole bunch of provisions. It's an 18 U.S. Code, Section 922. So you want to Google that. And this particular section is 922G. And you go to that subsection, and it talks about being convicted of a crime of domestic violence, including a misdemeanor. And by the way, a lot of people don't understand that. And I've had people tell me they didn't necessarily get good legal advice, for instance, on this point. They say, well, hey, I thought if I just pled to the misdemeanor, even though it's domestic violence, I wouldn't lose my gun rights because it's only a misdemeanor. Wrong. That's wrong under both state and federal law. But there's a second provision of the federal law under the a so-called Lautenberg Amendment that says that also, if you are the subject of a restraining order or order of protection, and that order of protection seeks to prevent you from contacting or otherwise harassing a spouse, former spouse, someone with whom you lived, or with someone with whom you've shared a child. Included within the classifications of people protected are those, so it's clearly focused at domestic violence. If you're the subject of a order of protection or restraining order, and the person being protected by that falls within those categories, including former spouses, girlfriends, boyfriends, someone you lived with, not just all boyfriends or girlfriends, but you lived with or you shared a child with or you were married to, then you can't possess a gun. But very specifically in that statute, it says the protective order must have been issued following an evidentiary hearing to which you had notice and the opportunity to appear, the opportunity to be represented by counsel, the opportunity to present evidence, and the opportunity to face the witnesses against you, to confront the evidence against you. Why? Because that's due process. That's how it works. And the federal statute specifically recognizes that. And the people who drafted the bill that became the Lautenberg Amendment to the Gun Control Act of 1968 had taken the time to read the 14th Amendment to understand due process. And that's why they wrote it that way. Connecticut missed the boat. We're going to take a break. What do you think about that? What questions and comments do you have? By the way, I've been on a bit of a rant about this Connecticut statute for obvious reasons. But here on the Gun Guy Show, we always want to take your questions and comments on whatever gun-related topic you want to talk about. You got a related issue in terms of protective orders or something completely unrelated, but otherwise within the general topic here on the Gun Guy Show, which is what? Guns. Give me a call. 239-9393, pound 9393 from your cell phone. Give me a shout out on Twitter at Guy Relford, or check out the Gun Guy Facebook page at Gun Guy WIBC. We'll be right back. This is Guy Relford on the Gun Guy Show on 93 WIBC.
He's a Second Amendment attorney. He's an N.R.A. certified firearms instructor. He's the Gun Guy. Guy Relford on 93 WIBC.
All right, welcome back. This is Guy Relford on the Gun Guy Show on 93 WIBC. Producer Ethan rocking some Joe Bonamassa. Let me tell you, I've seen Joe Bonamassa 3 times, and if you like guitar, you got to check out Joe Bonamassa. Everybody says he's the world's greatest guitar player that no one's ever heard of. I saw him at the N.R.A. twice. I saw him up at a little theater in South Bend, Fort Wayne, and that was just incredible. But doesn't have much to do about guns, but I am a huge Joe Bonamassa fan, so I'm glad we're getting to share a little bit of that with you guys tonight. All right, we're talking about restraining orders and how you can lose your gun rights if you're subject to a restraining order, and also how you can lose your gun rights if you're convicted of a crime, including a misdemeanor of domestic violence. And that's true both in the federal level. It's also true here in Indiana. If you're convicted of a crime of domestic violence, you lose your gun rights. And we also have a statute. It's a little different than the federal statute, but we also have a statute that says that a order of protection can protect a domestic partner or former domestic partner. And as part of that order, the court may prevent the person who's subject to the protective order from possessing firearms, and may actually direct local law enforcement to go out and seize guns and ammunition from that person subject to that protective order. And it's that second part that actually is more relevant, because you're already going to lose your ability to possess a gun under federal law if you're subject to a protective order, and that order is protecting a former spouse, someone you've lived with, or someone with whom you've had a child. So you already lose your ability to possess a firearm. But in Indiana, the local law enforcement where you live can actually be ordered to come out and seize firearms from you. Now, what we're going to talk about after the break at the top of the hour is, all right, once you've lost your gun rights in these areas, can you ever get them back? And that's a question a lot of people have. And we're going to get into that here in a little bit. But before we take a break, let's go to the phone lines. And we've got, can't quite read. Is it Julio?
Yes, it is.
All right, buddy. Welcome to the Gun Guy Show. What do you have for us?
That was the question what you just said right now. If you were charged with a domestic violence and you lose your gun rights and then you go back to court, after probation, probationary period, are you still able to regain your gun rights again if it was out of state?
Okay, no, well, let me back up. So was the original conviction for domestic violence out of state?
Yes.
Okay, well, that's going to be a little bit more of an elaborate process. There in Indiana, and that's to some degree going to depend on the law of the state where the conviction occurred. So, Julio, I'll tell you what, keep listening to the program because we're going to get into these issues. We've got to take a break right now, and we'll see if we can address that. But for right now, we're heading into the top of the hour. We're going to take a break. This is Guy Relford on the Gun Guy Show on 93 WIBC.
Thanks.
A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. This is the Second Amendment, and this is the Gun Guy.
Boom, 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 boom. Bang, 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 bang. Boom, 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 boom. Bang, bang, bang.
With Guy Relford on 93 WIBC.
And welcome back. I'm Guy Relford. This is the Gun Guy Show on 93 WIBC. We've been talking about new statute about to go into effect in Connecticut where a person simply accused of domestic abuse such that a temporary restraining order has been issued without a hearing, without any notice, without the ability to defend yourself, to confront witnesses against you, to be represented. Without any of those rights, the person who's the subject of that protective order loses their Second Amendment rights. And they have to actually sell their guns to a licensed dealer within 24 hours or turn them into law enforcement in order to not violate this new statute and presumably go to jail on that basis. No due process, none whatsoever. And I've got a couple of comments or questions on Facebook I want to respond to. With the law you're discussing, could I not immediately disarm my wife by claiming abuse? Sam just asked me that question on the Gun Guy WIBC Facebook page. And Sam, the answer is absolutely yes. Now, again, this is a Connecticut statute, so thankfully we don't have anything like this in Indiana, and I don't believe we ever will, because I fully believe our legislators understand the 14th Amendment and understand the requirement for procedural due process. But yeah, sure, all it takes is an allegation. And by the way, I had another comment on Twitter that I absolutely loved. And this is from Russell. Russell said, every Connecticut citizen should accuse their government officials of domestic violence, and we'll see how long this law lasts. Russell, that's a great point, buddy. There are legal ramifications to making false allegations in court documents, and you essentially, swear at the bottom of this form that what you're saying is true. Subject to penalties for perjury. At least that's how it works in jurisdictions I'm familiar with. So you don't want to run around falsifying court documents by making false allegations. But the point you make, and I know you're not suggesting that, the point you're making is that if some of these legislators were subject to false allegations themselves and lost their rights without due process, wouldn't they have a little more respect for the Constitution? And I think, Russell, your point is a perfect one. And I know, because I know you're not suggesting making false allegations. Yeah, once you're the victim, an innocent victim of the loss of constitutional rights without due process, yeah, you're going to gain a whole new respect for the Constitution. And one thing that my son Craig said to me, Craig's been a lawyer now for a couple of years and an outstanding lawyer at that. But we were working on a case together, one of my Second Amendment cases. And Craig said to me, he said, how I'm starting to look at these constitutional questions. When we're looking at the conduct at issue, and that we as constitutional lawyers say is illegal and that violates some particular provision of the U.S. Constitution. Craig said, how I'm starting to evaluate this in terms of how I approach it? He said, I asked myself, how would we feel if the redcoats were doing this? I love that. I love that because it's the historical context of the experiences of the founders that led to the writing of many of the constitutional provisions, both the Constitution itself and the amendments. The Bill of Rights were ratified in 1791. And then we've had obviously additional amendments since then, including the 14th, which requires the states to also comply with the requirements of due process, among other things in the 14th Amendment. But how would we feel if the redcoats had imposed a law in 1772 that said, what all the Crown has to do is make an accusation of a crime against you and your property, including your firearms, your arms of all types, can be seized from you? I'm pretty sure that would have factored directly into what ultimately led to the American Revolution. And so I like that approach. I've started to use that one myself. My friend Martin on Facebook said, thus, why I won't consider any jobs either in California or on the East Coast. I had an offer from a firm in Hartford, Connecticut. No way. And you know what? Martin, who's a buddy of mine, makes a great point in his comment on Facebook, because that's absolutely true. Don't think that some of these attacks on the Constitution, even in the name of protecting victims of domestic abuse, which is obviously something we all want to do. We all want to prevent domestic violence. We all want to put true domestic abusers in jail. And I've got no problem once you've been found by a jury to be guilty of a crime of domestic violence. I've got no problem with you losing your Second Amendment rights. I'm okay with that. But you want to do ultimately what in every other state and under federal law is only accomplished with due process. You want to do that in Connecticut without due process? You want to snub your nose at the Constitution? Don't think that won't keep jobs out of your state. Don't think that won't keep qualified applicants, highly trained, highly educated applicants like my friend Martin. Don't think that won't keep those skilled people you want to attract to your state. Don't think it won't keep them out. Sure as hell will. I think we just saw an example. We've seen companies leave some of these. It's not just anti-gun, it's anti-constitution states, at least in terms of their current legislatures and the people sitting in their governorships. All right, let's go to the phone lines. Let's go back, and we've got, I believe it's Ken. Ken, welcome to the Gun Guy Show, buddy. What do you got for us?
Hey, Guy. Enjoy your show. Very, very informative.
Thank you, sir.
I've got a question off topic, if you don't mind.
No, I don't mind a bit. Hey, is it about guns?
Yes, it is.
Well,
yeah.
Well, then it's not off topic. You go right ahead.
There you go. I'm a sportsman, and I know guns through that, but I feel I need personal and family protection on me.
Yep.
I've been looking at these pistols with the laser on them.
Sure.
Is that a deterrent, Guy? Whenever your aggressor sees a red dot on his chest, well, is that seen as a deterrent? I mean, I don't want to shoot nobody, but that red dot, is that a deterrent, or what do you think?
Nah, Ken, it's a great question, and it's one that I've addressed, in my classes.
I figured you had.
Yeah, and but it's a great question. I'm glad you bring it up, because there's actually a lot of misunderstanding about lasers, and part of it is from people seeing them on television and movies, and seeing how that's a pretty chilling effect. If I'm doing something and all of a sudden a red dot appears in the center of my chest, such that I know there's a gun pointed at me, the effect that has a lot of times when we see that scene in movies and television shows is, that person stops doing what they're doing because they know somebody's got a gun pointed dead in the center of their chest. The problem with that is that fundamentally, let's take 3 steps back. I don't believe in pointing guns at someone as a deterrent in most cases. In other words, I'm not going to use a gun at all unless I've decided that I don't have any other options to defend my life or defend my family's life or defend some other innocent life. And that means once that my gun clears my holster, or once that gun, comes out of the nightstand safe, whatever the application is, I've made the decision to defend my family. And I fully respect Ken, not wanting to shoot anybody. I don't want to shoot anybody either. I hope to go through the rest of my life without having to speak harshly to anyone, much less shoot them. However, because a gun is a tool of last resort, and because I don't want to make any assumptions about my assailant. I don't want to assume that they're sane. I don't want to assume that they're sober or of right mind generally. I don't want to assume that they're going to react rationally to a stimulus like a gun being pointed at them, or a red dot being on their chest, or the sound of the racking of a shotgun. You hear that all the time. Well, I keep a shotgun under my bed, and if I hear somebody in the house, I'm just going to go ch-ch, and that's going to make that bad guy go running for the hills. Well, some bad guys, it clearly will. Other bad guys, it's going to tell them where you are. And a laser can have exactly that same effect. If they see the source of the laser, well, now it's dark, but they know exactly where you are. And so using something like a laser, whether you're in your home or out in public, I'm not saying it couldn't ever be an effective deterrent, and it may allow you to prevent having to pull the trigger, and that's a good thing. If we can avoid pulling the trigger, we want to avoid pulling the trigger for a whole variety of reasons. But I don't think I would ever equip a gun with that intent up front. I just think that's dangerous. While you're pointing the gun at them thinking, okay, now you should be scared and be running right about now, they're looking at the point of origin of that laser, pulling their own gun and pulling the trigger, because they don't have that same hesitancy you do about taking a human life. The other issue with lasers that I have a problem with is that and I think they're sold sometimes. I don't know if it's intentional or sometimes people just kind of, I'm talking about folks in the gun shops and whatnot. The good gun shops, the ones that I frequent and respect, would never do this, but I worry about the big boxes sometimes, and I don't want to lump everybody together. But at any rate, I think sometimes lasers get sold to people who believe that they essentially can't miss with a laser. All they got to do is put that red dot where they want the bullet to go. And I think people start thinking of them sort of, as creating a smart bullet, like that bullet just follows that laser. And as long as you got the laser sitting in the middle of somebody's forehead, well, that's where you're going to shoot them. That's not how it works. If you haven't learned the fundamentals of handgun marksmanship or rifle marksmanship, whatever it is, in terms of how to hold that gun steady, how to align the sights on target, including how to hold the gun steady with a laser on it, how to activate the trigger in such a way that doesn't make the gun move. That's the hardest thing about shooting any kind of gun, is to pull the trigger without making the gun move. And the laser doesn't help you do that. In fact, it can give you a false sense of security that makes you think it's less important to be good at all the other fundamentals. So I'm not really opposed to lasers. I have a couple of guns that have a tactical module on them that includes both a light and a laser. And I think they're a great training tool. I think for you to put a laser that's mounted to a gun, a gun that's been cleared, absolutely positively it's empty, but to hold that laser on a really small item, like the switch on a light switch from across the room, and with an empty gun, do dry fire practice where you actually put that laser on that small little switch and practice pulling the trigger, making that gun go click without the laser moving off that little light switch. Well, what are you doing? You're training yourself to have a really good trigger pull. That's going to help you be a better shot. And a laser can help you do that with that kind of a training drill. But I don't think I would ever mount one, Ken, to answer your question, for purposes of being a deterrent. I don't think you can expect that person to react rationally, and I wouldn't want to hesitate while I'm in the process of bluffing, because I don't want to shoot them. They're in the process of killing me. I just don't think I want to approach self-defense in that way. But it's a great question. I'm glad you raised it. Hey, we're late going into this break. We're going to get back to our discussion about restoring your gun rights if you lose them. We had a question from Julio about that before the break at the top of the hour. I want to get back into that discussion because it factors in to our topic throughout the show about losing your gun rights through a protective order or through a conviction for a crime of domestic violence. So continue to join the discussion, 239-9393, 239-9393, or contact me on Twitter at Guy Relford, on Facebook at Gun Guy WIBC. We'll be right back. This is Guy Relford on The Gun Guy Show on 93 WIBC.
Second to none on the Second Amendment. This is The Gun Guy with Guy Relford on 93 WIBC.
And welcome back. This is Guy Relford on The Gun Guy Show on 93 WIBC. And we're going to switch topics a little bit. We've been talking about how you can lose your gun rights. In Connecticut, you can lose your gun rights with absolutely no due process whatsoever, which to me is nuts. It's illegal. But even here in Indiana, that I wouldn't label Indiana so much pro-gun. I think we're pro-Second Amendment in terms of what our legislature has done. I think we're pro-civil rights, including the right of self-defense. But even here in Indiana, you can still lose your gun rights, but with due process. If you're either convicted of certain crimes or you are the subject of a protective order after due process, after you've had a hearing, then that can deprive you under actually federal law and under a provision of state law, you can lose your Second Amendment rights. Well, if you've been convicted of a crime, any crime, and that crime, that conviction for that crime causes you to lose your gun rights, can you ever get them back? Well, the answer to that's yes, potentially, depending on the crime. And in fact, Indiana has changed its law to some degree to give more people the opportunity to have their rights restored. And our, what we call expungement statute has gone through some revisions, clearly, that the Indiana General Assembly and our governors who have signed these changes into law, particularly here recently, Governor Pence, clearly they intend to give more people the opportunity to get their rights back. And I think that's a good thing because it's not everybody. You have to qualify. And you have to go through a court process. But you can potentially get your rights back. So let's just talk about, for instance, a felony conviction. Let's say you have a low-level felony conviction from 20 years ago. And I get this call all the time at my law office. I'll get a call from a person, for instance. I got a call from someone who had a 30-year-old conviction for dealing marijuana. The person had been a member of the clergy. In fact, the dealing marijuana charge actually occurred when he was in seminary, while he was still going to school. And at the time, a long time ago, the amount of marijuana involved, which is a very small amount, it was still a felony. And he actually only had to do whatever jail time was involved in the initial arrest. The rest was suspended, so very little jail time. But because he had that felony conviction, under federal law, if you have any felony conviction, it doesn't matter how long ago, doesn't matter what level of felony it was. And this is what we call a D felony. Now they've changed the classification system, and now it would be what we call a level 6 felony. They've gone from letters to numbers, and they've added a couple of categories. So now the lowest level of felony is a level 6. By the way, if you hadn't heard this before, if you didn't know this, do you know the difference between misdemeanors and felonies? It's how much time you can spend in jail. A misdemeanor is for crimes where you can be sentenced up to a year in jail. A felony is for more than a year. So if you're convicted of a crime for which you could have been sentenced to more than a year in jail, doesn't mean that you actually were. It means you could have been, based on the definition of that crime in the statute. if you could have been sentenced to more than a year, that's a felony. Well, if you have any felony conviction, as I mentioned earlier, doesn't matter when, doesn't matter for what, federal law, this is part of that same gun owners, the Gun Control Act of 1968, and it's been changed and updated. It includes the Gun Owners Protection Act of 1986. But through that whole federal legislative scheme, if you have any felony conviction, you can't possess a gun. And you get caught with a gun, you are what the feds call a felon in possession, and you're looking at 10 years at Club Fed, which is no fun. So how can you ever get those rights back? Well, Indiana, as I mentioned, has changed its expungement statute. And if you have now, as the gentleman, just by way of example, we do a lot of expungements in my office. I met a client at my office at 10 o'clock this morning for us to sign his expungement petition, which we're going to file on Monday. And as we're doing several of them, and it's a way for people to get their rights restored. But if you have a low level, what we call a level 6 felony, and you have a clear record for 8 years, and there are certain felonies that are exempted, including a felony where someone sustained bodily injury. There are sex abuse or sexual crime convictions that are accepted if you were convicted of official misconduct as a public servant who was in office at the time. And that's just a few of them. So there are exceptions. But if you don't fall into one of those exceptions, you can, and you've had a clear record for 8 years, so you haven't had any other convictions since then, you're not currently the subject of a prosecution, you met all conditions of your order of conviction or order or probation. In other words, if you had to go to counseling, you went to counseling. If you had to pay restitution, you paid restitution. So you did everything you were supposed to do. You've now had a clean record for 8 years. You can get that expunged. If you've been guilty of a higher level felony or a felony in which someone did sustain bodily injury, then that can be a little different process. So some of the more serious felonies, it's no longer a mandatory process where a judge has to expunge your record if you meet the conditions. It becomes discretionary. But you can get those things taken off your record. And if it's a felony, and it's that felony that's keeping you from restoring your gun rights, then you can get that wiped off your record. Now, a very significant change that just happened last end of October. In fact, the letter from the ATF was dated October 28th, if I remember correctly. The feds had taken the position for quite some time that Indiana's statute on expungements did not restore your rights. The feds changed their mind on that after a couple of changes to our expungement statute by our legislature. And I'll explain more about that. If you have questions about that, give us a call. You have any other questions, gun-related, give us a call at 239-9393. Contact me on Twitter at Guy Relford or on Facebook at Gun Guy WIBC. We're going to take a break. I'll continue this discussion, and we'll continue to take your calls. This is Guy Relford on The Gun Guy Show on 93 WIBC.
Your rights, your responsibilities, your guns. This is The Gun Guy with Guy Relford on 93 WIBC.
And welcome back. I'm Guy Relford. This is The Gun Guy Show on 93 WIBC. And we've been talking about a variety of topics, including getting your gun rights back if you lose them. And I just was talking about the expungement process. And the change that came from the feds just late last year, end of October, is this: the feds had taken the position that because Indiana's expungement statute, when you file what's called a petition for expungement to try to take a felony off your record, and by the way, this is available for misdemeanors as well. In fact, you only have to have a clean record for 5 years to file a petition for expungement of a misdemeanor. But when you file a petition for expungement of a felony in Indiana, and if the judge grants that petition to expunge your records, they don't actually totally remove the conviction from your records. They seal your records. And law enforcement can still see that conviction on your record. And if you get in trouble again, that conviction can be resurrected, can be put back on your record if you get convicted of another crime. Because Indiana's statute didn't result in completely wiping a felony conviction off your record, and because it could come back, the feds historically had taken the position that an expungement under Indiana's statute didn't restore your gun rights. You'd still be a felon in possession under federal law. And for that reason, even people who were getting expungements weren't getting their licenses to carry. They were still getting turned down when they tried to buy a gun and went through a NICS check. Well, the change that occurred the end of last year, end of October, is the feds, after specifically being pushed on this issue by Senator Brent Hirschman. So if you're in the senator's district or you know him, say thank you if you care about your gun rights, because he pushed them and said, wait a minute, under federal law, it says either if you've had a conviction expunged or you've had your rights restored under federal law, you're supposed to be able to lose that disability, to overcome that disability under federal law to possess a gun. And in conjunction with that, our General Assembly actually tweaked the expungement statute to say specifically that an expungement under certain sections of the expungement statute did specifically restore your civil rights. And based on that little tweaking of the law and based on Senator Hirschman pushing the feds reversed their position and said, you know what? If there's the right language in your order of expungement restoring your civil rights, then we are going to recognize an expungement under Indiana statute as restoring your gun rights. And they communicated that to the Indiana State Police, who issues licenses to carry. So now, if you go through an expungement and your lawyer puts the right language in that petition for an expungement and the right language in the proposed order you're asking the judge to sign, specifically language that restores your civil rights, including your right to possess a firearm, then that will restore your rights. And you can buy a gun and pass a NICS check, and you can get your Indiana license to carry a handgun. Those are all very important changes in the law. And we want to make sure everybody's aware of those. Now, we started the show talking about this wacky Connecticut statute that's going into effect that had to do with being under a temporary restraining order for domestic violence and how you can also lose your rights if you get convicted of a crime of domestic violence. Well, Indiana's expungement statute says very specifically that an expungement of a felony does not restore your gun rights, does not restore your right to possess a firearm. I misstated that, a crime, not just a felony, a crime of domestic violence, a conviction for a crime of domestic violence, once you get it expunged, that expungement does not restore your right to possess a firearm. But there's a separate process in a separate statute for restoring your right to possess a firearm after a conviction for a crime of domestic violence. It's just a separate process. It's a different process than expungement. So I kind of butchered that a little bit in explaining it. It's a different process than getting a felony expunged. So let's say you have a misdemeanor conviction for a crime of domestic violence. And that'll prevent you under Indiana state law from getting a license to carry a handgun. It'll prevent you from under federal law and Indiana law as well from possessing a gun at all. You can go through a two-step process. You can, one, have it expunged, or if you don't want to worry with getting it expunged, to take it off your record or seal your record is more accurate. You can go through a separate process. If you've had a clean record for 5 years, you can get your rights to possess a gun restored even after a misdemeanor crime of domestic violence. If it's a felony, you need to have it expunged because the felony alone will keep you from being able to possess a gun, and because it's a conviction for a crime of domestic violence. Now, if somebody got hurt, if there was bodily injury involved, that makes it more complicated, makes it a lot harder. At some point, it becomes discretionary and the court doesn't have to grant it. But the point I want to leave everyone with throughout this discussion is Indiana has gone through an effort, and to some degree the feds have now assisted us, that it is more likely and more possible to have your gun rights restored under Indiana law than it's been in a long, long time. That's no guarantee, and it can become discretionary, especially if somebody got hurt during the commission of the crime that you were convicted of. That can make it very, very difficult. But if it's a nonviolent felony or it's a misdemeanor that disqualifies you for whatever reason, there are ways now under Indiana law to get those things fixed. All right, let's go to the phone lines, and we've got Tom. Tom, welcome to the Gun Guy Show, buddy. What do you have for us?
Well, I have a couple questions. Number one is I got a friend that he has a felony from, 5-6 years ago.
Uh-huh.
So he wouldn't be able to be a sponge, but he was wanting to deer hunt. Now, from what I heard, you can even with a felony, you can use like a muzzle loading firearm. Is that true, or is that not the case?
Yeah, well, there are firearms that actually fall outside the definition, the legal definition of firearm, because they don't fire a fixed projectile, and because they're either a gun that was actually produced prior to, I believe it's 1898. Or a replica of that same gun produced on or during or before 1898. Don't quote me on that statute. I want to say it was like July of 1898. But if it's an actual gun, it's an antique firearm or a replica of an antique firearm, and it does not fire a fixed cartridge, then that falls outside the definition of a firearm for purposes of the law that says felons can't possess firearms.
Well, this would be more of a modern firearm, like a modern muzzle loader that you'd have to drop the pellets down the barrel and then the projectile, and then you'd have to put your primer in.
Yeah, sure. And I know exactly how those work. I would want to know the specific firearm and then take a look at the statute before I'd want to give any very specific advice. The general idea is that antique firearms don't fall within the definition of the legal definition of firearm for purposes of that statute. But I wouldn't want to get too specific, Tom, on telling you, oh yeah, any muzzleloader falls outside the prohibition of a felon possessing a gun. I'm not willing to go there. I'd want to take a specific look at the statute before I get any more specific with you on that.
Okay. And then on the second question, as far as an individual with a misdemeanor, now, is that any firearm they can't, or just handguns they can't have?
Well, no. If you have a misdemeanor conviction generally, that doesn't prohibit you from possessing a gun unless it's a misdemeanor crime of domestic violence.
Yeah, I have a friend that has that conviction on.
Yeah.
So, and he what he did is they did a plea bargain down to a misdemeanor, and he did it with the idea of thinking that it would preserve his ability to own his guns or keep his guns, and he wasn't aware that he was going to lose.
Yeah, that happens a lot.
Right.
I think I even mentioned that during the show. A lot of times people say, hey, if I plead it down, sometimes people will say, well, I got charged with domestic battery, but if I plead it down to simple battery as a misdemeanor, then I won't have a problem with my gun rights. The problem is Indiana has a broad category of crimes, not a specific crime, but a broad category of crimes called crimes of domestic violence. And if they involve the use or threat of force or the use of a deadly weapon, and it's done against a certain classification of people, including people you live with or had a kid with, then those are crimes of domestic violence, even though it's not the specific crime of domestic battery. And at other times, even if it's domestic battery, people think, well, if it gets pled down to the misdemeanor, it won't affect my gun rights. It does, and they're still prohibited. So, so the answer to your question is, if they've been found to have committed either the specific crime of domestic battery or a crime that falls within the category of a crime of domestic violence, they can't possess a gun at all, is the answer to that question, Tom. But we thank you for calling the show. So I'll tell you what, we're a little late going into the break at the 3/4 hour. See, we got our buddy Westside Dave on the phone, so Dave will be right to you after the break. We'll be continuing to take other calls as well, so give us a call at 239-9393. This is Guy Relford on the Gun Guy Show. We'll be right back on 93 WIBC.
Now you've got a gun guy. Guy Relford on 93 WIBC.
And welcome back. I'm Guy Relford on the Gun Guy Show on 93 WIBC. And I'll tell you what, we got a bunch of people on hold, and we've got about 3.5 minutes to go in the show. So I'll tell you what, I'm going to try to get to everybody. So the challenge is, please state your question or your comment real quick. I'll try to address it as quick as I can, and then we'll get right down the line. So right to Westside Dave. Dave, what do you got for us, buddy?
Hey, Guy. What is the purpose of a decocker? And I don't like them. Should I go get a gun with one?
Great. Thanks, Dave. Thanks for calling. We always love you calling the show. Yeah, a decocker is just what it sounds like. If you've manually cocked the gun, or the gun has just been cocked, for instance, when you load a new magazine and you need a chamber around, and most of us carry with a round in the chamber. If you're not comfortable doing that, I say take more training. But just the process of putting a round in the chamber, you rack the slide. Well, now on a gun with a hammer, where's the hammer? The hammer's cocked. And you're not going to carry the gun with a hammer cocked, so what you need to do, you need to decock it. So a decocker is a way to safely lower the hammer on a gun without the gun going off. And I tell you, I've got a Beretta 92G. It's a Wilson Combat Edition Beretta, and the decocker is fairly violent on that thing. When you hit the decocker, that hammer goes smack. I mean, it makes the sound like it makes when it fires, which spooks you a little bit. I've got a SIG 229 Extreme that has a decocker, and it sort of gently lowers the hammer, which is a little easier on your nerves. And I mean, I know that Beretta is not going to fire when I decock it, but it makes a pretty loud clicking sound, and it drops that hammer pretty quickly, which can get your attention. But that's the purpose, Dave. And I've had guns with them and without them, because your only other option to decock the gun is to put your thumb on the hammer spur and gently pull the trigger and hope your thumb doesn't slip off, or else you're going to fire the gun. That's not a safe thing to do. Now, other guns like a 1911, you carry cocked and locked, so you don't have to worry about decocking it, because you carry it cocked. Why? Because it's got a palm safety and a thumb safety, and you carry it with the trigger protected, so that's all very safe. All right, let's keep going, and we've got Horace, I believe. Horace, what do you got for us?
Well, I'm something of a machinist.
Yes, sir.
I can drill holes and put on threads and weld stuff and mill stuff.
Uh-huh.
If I go in my garage and grab metal and I come out with something that produces bullets or fires bullets, have I done something wrong, or am I within my right?
No, it's a great question, Horace. Well, visit the ATF website, and there's a specific Q&A about essentially homemade guns. But what I believe you'll see there when you visit their website is the federal government says, and there's nothing different in Indiana, that you can make a gun yourself and without serializing it, and without registering. We don't have gun registration in Indiana, but registering it even with the federal government, so long as it's purely for personal use. Purely for personal use. If it is for anything other than personal use, or if you ever try to transfer it, then you'd be violating federal law if it wasn't serialized and registered with the government through the serialization process. But check the ATF website. I'll defer to them, but that's what I believe you'll see there. And hey, we're at the end of the show. I didn't get to one caller. I'm sorry about that. But join us next week. This is Guy Relford on the Gun Guy Show on 93 WIBC.